Hello and welcome to the Minimum Competence episode for Monday, November 18th, 2024. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, Trump's hush money case, Kathy Vidal's return to Winston and Strawn, Spirit Airlines bankruptcy, the Supreme Court's early opinion, and my column on reforming 501c4 to curtail dark money in politics. Let's remember, the misfortune of a wise person under a foolish leader is akin to a rich person drowning in a river of gold. And read today's legal news. On this day in legal history, November 18th, 2003, the Massachusetts Supreme Judicial Court issued a historic decision in Goodridge v. Department of Public Health, becoming the first court in the United States to rule that a state ban on same-sex marriage was unconstitutional. In a narrow 4-3 decision, the court held that the denial of marriage rights to same-sex couples violated the Massachusetts Constitution's guarantees of equality and liberty. Writing for the majority, Chief Justice Margaret Marshall emphasized that marriage is a civil right and that excluding same-sex couples from this institution created a second-class status inconsistent with constitutional protections. The court ordered the Massachusetts legislature to take corrective action within 180 days, either by revising existing laws or crafting a new framework that would extend marriage rights to same-sex couples. Importantly, the ruling did not permit civil unions as a substitute for marriage, affirming that anything less than full marriage rights would perpetuate discrimination. This groundbreaking decision made Massachusetts the first state in the U.S. to legalize same-sex marriage, sparking national debates over marriage equality. The Goodridge decision laid the foundation for subsequent legal battles over marriage rights and catalyzed movements for LGBTQ+ equality nationwide. While celebrated as a milestone in civil rights history, the ruling also ignited opposition, prompting efforts to pass constitutional amendments to define marriage as between one man and one woman. Despite the controversy, Massachusetts began issuing marriage licenses to same-sex couples in May of 2004, cementing its role as a trailblazer in the fight for marriage equality. Former President Donald Trump's hush money criminal case is at a crossroads following his election victory. Trump was convicted in May of falsifying business records to conceal a $130,000 payment to Stormy Daniels during his 2016 campaign, but sentencing has been paused at the request of Manhattan District Attorney Alvin Bragg. Prosecutors must now propose how to proceed, balancing the political implications of prosecuting a president-elect with the need to uphold legal standards. Their recommendations are due tomorrow, Tuesday. Options for prosecutors include indefinitely delaying sentencing, postponing punishment until Trump exhausts appeals, or pursuing a sentence with minimal consequences, such as an unconditional discharge. Legal experts suggest Bragg is unlikely to seek aggressive penalties before the inauguration, given the potential political fallout. Trump's defense has long claimed that the case is politically motivated, arguing that it should be dismissed to avoid unconstitutional interference with his presidency. They also contend that his actions are protected by presidential immunity, though the court has yet to rule on this argument. The judge, Justice Margaret, will ultimately decide whether the case moves forward, with both sides expected to appeal any unfavorable decisions. Kathy Vidal, outgoing director of the U.S. Patent and Trademark Office, or USPTO, will rejoin her former law firm, Winston and Strawn, as a partner on December 16th after leaving the agency. Nominated by President Joe Biden in 2021, Vidal focused on policies addressing AI in patents, international intellectual property issues, and diversity and innovation during her tenure. She emphasized transparency and patentability standards for AI-assisted inventions to promote innovation without stifling it. Deputy Director Derek Brent will serve as acting director until President-elect Donald Trump appoints a replacement. Trump has not announced his pick, though his first-term USPTO head Andre Lansou prioritized policies favoring patent owners. Vidal noted that IP policy tends to be less partisan and highlighted the agency's unique funding model, which relies on processing fees rather than taxpayer dollars. At Winston, Vidal will advise clients on tech-related legal issues, including AI, cybersecurity, and antitrust law, leveraging her USPTO experience. The firm's leadership praised her ability to guide clients through challenges posed by technological advances and geopolitical pressures. Vidal expressed her intention to continue shaping tech policy at the intersection of law and innovation. Spirit Airlines, Inc. has filed for Chapter 11 bankruptcy amid financial challenges and intense competition from rival carriers. The filing in New York lists the company's assets and liabilities as between $1 billion and $10 billion. Spirit's troubles escalated after a federal judge blocked its proposed $3.8 billion merger with JetBlue Airways Corp., citing antitrust concerns that the deal would harm budget-conscious travelers by raising ticket prices. Previous merger talks with Frontier Group Holdings, Inc. also collapsed. The discount airline has faced increasing pressure from major carriers offering competitive basic economy fares, which have eroded Spirit's market share. Since the COVID-19 pandemic, the company has posted consistent losses, with its stock plummeting 93% in 2023. Spirit's bankruptcy follows an agreement with bondholders on a debt restructuring plan. Bondholders will convert $795 million of debt into equity, take control of the company, and inject $350 million in fresh equity, along with $300 million in debtor-in-possession financing to sustain operations during the bankruptcy process. The airline also plans to delist as part of the restructuring. In an effort to remain competitive, Spirit recently introduced upgrades such as extra legroom and free checked baggage to attract travelers seeking more premium options. However, these efforts have been insufficient to counter the financial strain. The case is being handled in the U.S. Bankruptcy Court for the Southern District of New York. The U.S. Supreme Court announced it will release its first opinion of the term on November 22nd, earlier than in recent years, where the first opinions appeared in December or January. The specific case or cases to be decided have not been disclosed, but they are likely from the 9 argued in the October session. These include issues like federal court jurisdiction, attorney's fees, and the requirement to exhaust administrative remedies before suing in federal court. Complex cases such as challenges to Biden's ghost gun regulations and an Oklahoma death penalty case are expected to take much longer. The timing recalls the court's earlier practice of releasing initial opinions in November, a pattern often attributed to Justice Ruth Bader Ginsburg's quick writing pace. In contrast, recent terms have seen delays, with the first opinion in the 2022 term arriving as late as January 23rd, marking an unprecedented delay since the court's October term structure began in 1917. This term, the court has already agreed to hear 45 cases, avoiding controversial social issues and focusing on lower-profile matters. The November 22nd release could include an opinion or even a dismissal of a case as improvidently granted, as suggested during recent arguments in an investor lawsuit against NVIDIA. And my column this week, a day early. The court ruling in Memorial Hermann Accountable Care Org v. Commissioner underscores the flaws in the current 501c4 tax-exempt classification and the need for reform to address the issue of dark money in politics. This tax code section groups together vastly different organizations, from advocacy groups like the NRA to local sports leagues, under a single classification. The lack of clear, enforceable standards allows some organizations to exploit their tax-exempt status to fund political campaigns while avoiding donor disclosure. This lack of transparency fuels the dark money problem. 501c4 organizations can engage in political activity as long as it's not their primary purpose, a vague standard that has led to inconsistent enforcement by the IRS. The Fifth Circuit's decision in Memorial Hermann challenges this leniency by applying a stricter, substantial, non-exempt purpose test, signaling a potential shift towards greater scrutiny of political spending by these 501c4 organizations. One solution is creating a new tax-exempt subcategory, 501c4c, for politically active social welfare groups. This would establish clearer rules, such as capping political expenditures at 50% of revenue and requiring donor disclosure for contributions above $10,000. It would also separate traditional social welfare organizations from politically active ones, reducing unnecessary regulatory burdens on the former. Breaking 501c4 into more specific classifications would ensure that transparency requirements target politically active organizations without disrupting community-focused groups. It would also help regulatory bodies focus enforcement efforts and prevent misuse of tax exemptions for untraceable political contributions. This reform aligns with public demand for accountability in campaign finance while preserving the integrity of non-political nonprofits. In sum, the 501c4 designation is problematic as currently drafted because it combines a wide variety of organizations with vastly different purposes under the same tax code section. This allows political advocacy groups to hide behind the same classification as traditional social welfare organizations and avoid stricter scrutiny. This structural ambiguity hampers transparency efforts, suggesting the need to separate these groups into distinct categories for effective regulation. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, talk sense to a fool and he will call you foolish.